issues keeping me away. So anyway, we'll go ahead and start. Looks like we have 3 items to discuss. The first, we have 3 requests for firm name approval. We have, let's see, well, the first one we'll start with is the Eaton and Hartung. From the information we have, it looks like when they submitted originally, there was an issue because they didn't have, was it 50 plus 1% ownership of the CPA firm. Is that correct, Mark?
Yes, that's correct.
But based on what I've read, they have corrected that information, and now they want to be called Eaton and Hartung PLLC.
Yes, that's correct.
And which I guess from reading everybody's opinion that is a compliant name. Any discussion on that?
I think the issue, Stephen, is they want to use, what is it, Karen? Hartung? No, Eaton is the one who's not the CPA.
Sorry. They would like to use the DBA Eaton Tax and Consulting, I believe.
Okay, hang on, let me keep on the right one. All right.
They would like to use Eaton Tax and Business Services, and Miss Eaton is a part owner of the firm, but she is not a CPA.
Okay.
We feel that the DBA is misleading since Miss Eaton is not a CPA, but they're operating under Hartung and Eaton and Hartung PLLC, and then they want to use the DBA using only her name and not his.
Okay, that's the last item I read. It just said we could use Eaton and Hartung PLLC. Does the committee have any thoughts, comments? I can't hear anybody, so I assume.
There's silence on this end right now, Stephen. I think they're thinking.
Okay, I was making sure.
Henry, you look like you want to say something.
Mark, as I understand it, the request that's being made is that they want to operate under the name of Eaton Tax and Accounting Service, and Eaton is not a CPA.
They want to use a DBA as Eaton Tax and Business under the Hartung and Eaton, or Eaton and Hartung PLLC name. So they've registered properly with the firm because Mr. Hartung is now 51% owner.
Okay.
They're not using the name CPA in the firm name. They're just using Eaton and Hartung.
And our legal counsel felt that the Eaton Tax Services would be a violation of Rule 0020-03.151D, being a misleading name based on the nature of the business.
Yes, that's what we believe. That's what that's staff's belief.
Okay.
Seems to me that this ought to be denied based on the fact it's misleading.
I would agree with that, Henry.
I'd make a motion that we deny this request.
Okay. So we've got a motion to deny the request, or recommend to the board we deny the request. Do we have a second?
I'll second that.
Okay, we have a second. Any other discussion? All in favor say aye.
Aye.
All opposed? Okay. Make a note here. All right, let's see. The next one is request from Pinnacle. My notes here.
Who's the second one?
Pinnacle CPA Professional Services PLLC. It's a request by Ronald Jelly. Is that right?
I think he
Gelée.
pronounces it gelée.
Gelée. Okay. And I think that the issue is whether or not the name Pinnacle, which is not obviously his name, is a misleading or fictitious name.
Mark, can I ask a quick question? I thought we had decided to table decisions on fictitious names until we had come up with some clarity on the issue we've been dealing with for the last 3 or 4 meetings. Is that not, has that already been resolved or not?
No, it has not been resolved.
Because we had, I think it was Compass East that was here last time that we just said we weren't going to make a decision on, right?
Right.
There was a white paper, I think, that was to be discussed.
It's going to be discussed in executive committee.
Yeah, so I guess based on that, we may want to just table both of these. There's one request for Dominus and one for Pinnacle. Table that until we decide what we want to do with fictitious names based on that white paper in our discussion at the board meeting.
That would be my suggestion to the chairman.
Okay, I would agree. Does anybody object to that? Okay, we will table. We'll keep the Eaton and Hawthorne or Eaton Tax and Service, our recommendation with that, and we'll table the Dominus and Pinnacle until the board meeting. The board discusses the fictitious names tomorrow.
Is it tomorrow we're going to have, we're talking about having the discussion on the white paper
I think that's coming up in executive committee
Yeah.
today?
today.
Okay. So
Okay.
we don't need to have that discussion here in this committee?
Create the agenda, but that's where it fell.
It's not on the agenda, but we can.
I mean, you can certainly get into it since you're dealing with fictitious names. As Mr. Watkins pointed out, the executive committee is going to be addressing it more directly later on, but I think this committee certainly has a stake in how that discussion goes.
Yeah, I would agree with that. Seems to me it probably should have been on y'all's agenda,
Yeah.
under y'all first. Because I think
I
this is
assume we
something
can
that
add
everybody
that,
needs to
correct?
discuss.
I assume we can add this as an agenda item to discuss, right?
I think you're free to discuss it. Yes, sir.
Okay. Well, I assume everyone's read the white paper.
Can I make a suggestion? Just
Sure.
as a matter of, not everybody is here from the board for the full conversation. Our chairman is not here yet, so I want y'all to be part of the conversation. I just think we probably ought to have everybody here when we have that conversation. I don't know how everybody else feels about that. I mean, I'm not trying to stifle the conversation. It just seems like we've been wrestling with this for several board meetings now, and it seems like everybody ought to weigh in if they can. I don't know if
I'm okay
everybody
with
has
that.
places to be after this, though, too, so. Vic.
No, I'm okay with that. I think honestly, the fewer limited conversations we have without the full participation, it's just going to get more confusing, I guess. And I would agree with Trey's comment.
Just in case I'm not here when that discussion occurs, in reading the white paper, it appears to me that the white paper's interpretation of misleading is not near as strict as this board has taken the position of, for what that's worth. Because the examples they use are like using corporation in a name when you're not a corporation, like professing to have some expertise that you don't have, influencing some regulatory body. So, and I know all of you will make your own interpretations, but my interpretation of what they say is not near as strict as what this board has been trying to impose on candidates that come before the board.
They don't seem to be wrestling with the problems that they mentioned in the white paper.
Right.
Yeah.
A whole different issue.
I did notice in that they talked about, somewhere in there they talked about the term fictitious and about the fact that that term in and of itself could be a little bit of a problem in trying to interpret what that means in relation to the names that are being put forth to us.
But they can use the example of if you're adding an association or alliance to your name, that at least the way I read it is they don't consider that to be fictitious. And if, well, some of you may not have been on the board, but back when we had this issue with Crow Horwath years ago, that was a big issue. North Carolina told them they couldn't use Horwath because that was the association they were with, and this same board wrestled with the same kind of thing. So I'm saying it appears to me that they're a little more liberal in their assessment than we have been.
In my reading of it, it seems like the misleading part is the most important piece of a firm's name, and they did kind of downplay the fictitious, if somebody wanted to use Pinnacle and even looking at some of the current registered firms, there are quite a few firms that don't seem to have a person's name or even their initials that are currently registered. So it does seem the white paper downplays that fictitious name piece.
I think it even went, I'm sorry,
No, go ahead.
it went further to say that you want to be able to determine who the ownership structure is, and as long as they were properly registered and the information was easily determinable, I guess, that wasn't a problem.
Right. Yes.
Right.
I think we've always taken the opinion too, though, that I guess in our discussions that if it misleads as far as the best accounting firm in the world, or I don't know, I think there was a term that meant master account. I think that it doesn't specifically state that in the white paper, but I think that was the issue, at least for me, that I kind of wrestled with was, can we let a firm declare themselves to be the best firm or the greatest firm or a master CPA firm? That's kind of where
I think it did say something though about unreasonable expectations or something from, I think I read that. So like when you use those words, to me, that might cross that line.
I think the example it gave on there was something like maximum refunds, achieve a certain favorable results, like, get you back the most money CPA firm or something. I think they use maximum refunds actually, but I think it all does kind of tie in.
I perhaps took a harsher view of the paper. Y'all are putting a nicer spin. I didn't think it was on point at all with our issue. I mean, our issue is about the things we've grappled with in the last 3 or 4 meetings have been about crazy spelled words or names that just kind of come out of nowhere. And I don't think the word misleading, I think it's very under-inclusive in terms of guidance on how to interpret those applications for requests of names. And to me, even looking at the excerpt of different rules from different states, they kind of are the same. Most of them are in the same spot we are. They talk about misleading, but the question is, what does misleading mean? Is it just it's going to those types of examples that this paper talked about, or is it talking about a word that has no grammatical or logical sense made to it, or something that's a fine word but doesn't have anything to do with accounting services? And to me, it seems like we need to look at, maybe we have to chart our own territory here, but if we're going to go down this path, we got to use a different approach than whether it's misleading or not. Because if it's misleading, it seems like you're actively trying to deceive someone versus being potentially vague or ambiguous as to what it means. And I think our issue is on the latter. And so as a result of that, I didn't think this paper was that helpful at all, but that may be a little bit harsh. So, or maybe it's the result of our social media culture with Tumblr, spelling, leaving out vowels and words, and that's become the new thing. And that happened after 2009 when this paper was done. I don't know, but that to me was I felt like we might need to chart our own course here.
I know I'm not on this committee, but I want to weigh in because I think I agree completely with Gabe. I think this was not I would like to see a more current version. I think our problem, what we're trying to address, is a matter of respect for the CPA designation and what it represents. And what we've been seeing is totally veering off of that. And some of the other states, like Mississippi, is very specific about not even doesn't allow you to use a firm which includes any fictitious name. So it's state by state, and I'd love to see a more current white paper that actually addresses some of these, what we're looking at. And my fear is that, again, you open the door, where do you draw the line? And that I think was what we kept saying. If are we talking if they say if they use abbreviation for Bible verses, and it just gets so we could have A1, A2, AAA. I mean, it just becomes, at what point, when it's so safe to just say you should use your name.
Well, we've already issued some names that probably won't comply with whatever we
Right.
come up with, which
That's-
complicates it to some degree.
It does, but we can't
Right.
go backwards.
Right.
So
I think we're talking about everybody that's currently in operation right now, that we grandfather those people in, but we're talking about the requests that are coming up now and in the future. If I particularly liked the first sentence of North Carolina in this list that we got of what they're doing in different states. It said a CPA or CPA firm shall not trade upon the CPA title through the use of any name that would have the capacity or the tendency to deceive. I thought that was pretty good. If you've got any name other than the name of a partner or a prior partner, a past partner, or initials in the firm, I feel like that you've got some aspect of deception there as to who they really are.
Any other comments? Well, it's obviously an agenda item tomorrow for the full board, and I think it's probably best if we continue that discussion with everyone present. Okay.
Fine.
All right. The next item we have is discussion of audit of state-specific ethics sponsors. I believe at previous meeting we'd asked Mark and the staff to look into this as far as how do we make sure we maintain quality state-specific ethics and to make sure that those that we've granted are still compliant with our rules as far as providing those. Mark, do you have information to present to us?
Yes, Mr. Eldridge. Mr. Mills is passing it out now. I don't know if we emailed it to you or not, Stephen. Did we? The
Yes,
list.
I've got it.
Okay, good. I couldn't remember if we sent it to you or not. It didn't make it to the iPads.
Got it.
What you all are receiving is a listing of all of the providers of the Tennessee State-Specific Ethics course. The only ones that are not on here are our course and the TSCPA course. We did audit the rest of them. I believe that if you'll notice, there are several where they had no attendance records because they didn't. The course wasn't offered during the period that we audited. It was March 1st, 2000. I'm sorry, what were the dates? March 31st, 2014 through March 31st, 2015. That's what we audited. The only courses that seemed to be really popular that had a lot of attendance were the ones that Dr. Perry Moore did, the one that was offered by Western CPE, and the one that Thompson Dunlap is using is our course. I just gave it to Philip Babin and told him he could use it if he wanted to. So I think the staff is going to recommend that we put a time limit on these approvals and have them resubmit periodically instead of, as we have in the past, resubmit only if there's a major change in the course. If we set a time limit on it, then I think we have a better handle on what we're doing. We have several courses in here that are simply a reiteration of the law and the rules, and then you answer some questions and you're done. And I'm not sure that that's what we want out there as our state-specific ethics course.
Can I ask you a little bit more about your last point? That's kind of what I was thinking we may see as some type of qualitative analysis of the courses, maybe the number of people that participated, and then like a quality measure, like maybe one of our staff did it and be able to tell, is it really just regurgitating our rules and then having some questions that regurgitate the rules, or is there an interactive element or something like that? Do you have any more that you can flesh out with respect to quality that's not really reflected on this sheet?
We've actually got the courses and all the information, Gabe. So yes, if you'll look here, let's see, it's CP Easy. I don't think anybody took the BISC course. Nobody took Sequoia CPE. Lattimore Black is interactive. That's a live lecture type thing. Dennis Dickus didn't offer his during the time period specified. CPE Inc. That's a self-study. I'm sorry, that's a live presentation. Here again, there's no law and rules available. I mean, is that the type of thing you're looking for?
I was kind of wondering if we had somebody on staff that actually took each of the courses and had an opinion as to whether or not it was a good, like a high quality course or not. Whether it was something that's kind of slapped together, maybe something that had made sure this stuff was current. I didn't know if we had gone to that level or not.
No. Now, I have listened to Dr. Perry Moore, and I have listened to David Haddett, who does the one at LBMC. And I can tell you that both of those are good quality courses.
Do we have a requirement that they have questions?
We do not have a requirement that they have questions. If it is self-study, then NASPA has a requirement that they have questions, and we are following the CPE standards. So yes, they should have questions in order to be able to say that someone passed the course.
So under the current rule now, if a vendor comes in and wants to provide the CPE, they fill out the application, they submit the materials, we review the materials. What's the time limit as far as how long that approval is? Is it unlimited right now?
It's an unlimited time now. The rule that we have enacted in the past is you must resubmit if there are major changes to the course.
And then we have right now we have no review. We just assume that the materials they presented to us are kept up to date and still maintain the same quality. Is that correct?
Yes, that is correct.
I mean, I think when we discussed this, I don't think this was a couple meetings ago. I guess from my opinion, I would like to at least see some sort of quality control to where maybe we not review every single one of them, just like we do with licensing, but we pull a sample of them. Maybe every year we'll pull a sample of a couple or three, whatever the number is, and just review the materials and review the sign-in sheets and the evaluations and all that stuff that they're supposed to have to make sure that they're compliant.
We can certainly do that. I mean, we have not done that in the past, but I agree with you. I think it needs to happen. If this board's going to be responsible for this course, then I think that we need to have a better handle on how it's being administered and what's being put out there.
Well, Mark, clarification, what's the difference between column 4 and column 7?
I would assume that column 4 would be just any questions at all about the material, whereas number 7 is just on laws and regulation, or laws and rules.
But are you saying the teacher of the course has questions that he poses to the class, just general questions about ethics in column 4, and then column 7 would be more specific questions about law and rules?
Yes, I believe that's
how
correct.
I'm reading it, but I may be wrong.
And as far as the Tennessee State Board is concerned, we don't have a requirement that they do that?
No.
We have a requirement that they keep attendance?
Our requirement says that they must have a 2-hour state-specific ethics course. We have adopted the CPE standards, which do require attendance records and normally require evaluations. But I didn't force that, Henry. That's what I'm saying.
So the organization that's putting on the course would be required to have attendance records in order to give out their certificates that they give out.
Exactly. Yes, sir.
But we're not checking that now, though. We just assume they do it. That's correct.
Yes, that's correct.
Okay. I mean, I guess my recommendation would be, I'm not necessarily hung up on the, I mean, I wouldn't object, but to the fact if we approve somebody to do it, that, you know, they have to renew every year, as long as we were doing some sort of quality control audit every year of a you know, select number to make sure that they are in compliance with our rules and the material is compliant and quality and, you know, the best that, you know, we can give our members. That would be, I guess, my recommendation is that we would implement some sort of testing procedures on an annual basis of a sample of these, random sample every year.
To do that, you're going to have to establish some standard level of what needs to be in the material, I would assume. If you're going to grade them on something, they need to know what you're grading them on, right?
Yeah.
It'll make it
I mean, I
difficult
would
to regulate
assume,
if you don't.
I would base that on the same criteria we use when a new person applies. We review their material at that time, right, Mark?
Yes, I would think so.
And so I assume we have some sort of gauge to determine whether or not it is compliant and quality material.
Yes, there was an outline that was prepared several years ago that's given to the committee when they have a new course to review.
Okay. So, I mean, in theory, I guess what this would become is really just a renewal process in theory, and making sure that they've been compliant as far as, you know, requiring the attendance records and evaluations and such.
I think that's correct. I think that's the path we want to go down.
Anybody else have any thoughts? Any
We're a quiet
recommendations
group
for the
today.
board?
Are we recommending that the staff come back with a set of guidelines or to develop a set of guidelines for the each sponsor?
I guess my thought. I guess what I'm from here. Mark talked is we have those guidelines. And it's be the guidelines we use when we approve someone the first time. That outline he's talking about.
Yes, it's very general, but we're not doing anything to monitor future use or future changes if they're minor.
Would the recommendation be that we institute like an audit every year of some select number of these courses to make sure they meet the guidelines? Is that, Stephen, is that what you're asking?
Yeah, that would be my opinion. As we implement an audit process, a review of, like I said, to make sure they've got the compliance stuff, they've got the sign-in sheets, they've got the evaluations, and which obviously that's pretty much the bulk of it, and then also a review of the material. You know, I'd hate to see we approve somebody today, and 7 years from now they're still using the same materials, and the rules have changed 20 times over. So I mean, that was kind of my thought.
As opposed to an audit, why don't we just make it a requirement that in order for them to continue to have the ability to present their CPE, they have to send in their course material, attendance records
Periodically.
every year.
Every year or whatever, yeah.
I would be fine with that as well.
That'd be a lot simpler, I think, on management. That way you can pull whatever you want, whenever you want.
I like it. I like that idea.
Would that have to actually be a rule? Would we have to promulgate that in our rules?
I don't believe that you would have to, based on the reading of 0020-05-.04, subsection 1B, you have the authority to make sure that they are meeting the statements or standards. And so this is more of a administrative issue. In order to continue to qualify and to make sure that you all can evaluate, you can say, we need you to submit these so that we can evaluate them.
Okay. I assume we would just send out notice then saying effective this year or whatever period, this is what we're doing. Maybe somewhat cumbersome, I guess, I don't know how many, you mentioned Dr. Moore or Western CPE had several of these.
Yes, but here again, that we have those records. They sent them in to us for this audit.
Okay. That'd be my recommendation, is that we implement requirement that all ethics providing vendors submit all the compliance records, materials, sign-in sheets, evaluations on an annual basis, and that our staff review those to make sure we're compliant. They're compliant.
Got a motion?
I'll make that as a motion, and anybody makes a second.
I'll second.
Any other discussion?
This is Bill
All in
Office.
favor?
I have a question. We call this
Sure.
ethics. Isn't it rules and laws that we're talking about? Do we cover ethical questions in this course?
The outline provided by the board several years ago when this was implemented was simply to cover the law and the rules. It did not, because at that time you had a requirement for 1 hour of state-specific and 3 hours of general, and the ethics was covered in the general portion. So when we changed the rule to 2 hours of state-specific, there's no mention of general ethics.
I think ethics includes when do you resign from a client? When do you accept a client? How do you deal with personnel? It goes beyond just the laws and rules. So anyway, that's an observation. I'm not.
Yeah, I think it's a good point, Bill. I just always referred to it as the ethics CPE you have to get. But what would be the proper terminology for these courses, Mark?
That can be a discussion for some other time.
Okay. Any other discussion? All in favor, say aye.
Aye.
All opposed? Okay, we'll make that recommendation tomorrow. And the last item I've got is discussion is TSCPA as the sole provider of state-specific ethics. I think that's been a discussion in the past. Mark, do you have is Brad presenting something to us, or?
Mr. Floyd's here, and I think he wants to say something, as usual.
Okay.
I don't have anything. I don't have anything new to present, but I did want to state that it is still TSCPA's opinion that to have one high-quality ethics course that everyone takes that is very consistent with the information without having 20 different versions that we have to keep up with and audit. And our goal is to have something very soon to the board. We've got the software, we've got the authors. We're working with NASBA right now on some resources that they're going to make available, and they'd given us May 1 as their target date for that. But our goal is to work with the State Board of Accountancy staff, NASBA staff, and TSCPA to put together this gold standard. It would be an online course, and it's one that we could all agree is exactly what we want to communicate to the licensees. And we feel like that's the most efficient and effective way. It would be a low cost, if not free, available 24/7, and convey exactly what we want relative to a mix of ethics, potentially case studies, law, and rules. But it can be done. It can be done efficiently. We're working on it, and I hope to have something to you by the fall.
Did we
Thank you, Brad.
find that? I'm sorry.
No, go ahead. Any discussion?
We had, at one of our prior board meetings, we had discussed getting some information from Virginia because they had gone this route, if my memory serves me correctly. And I just can't recall if we ever really learned much from talking with them about, because there was 2 or 3 concerns that we had as a board. And learn anything from that at this point?
I don't think I remember. I remember discussing that. I think that our concern at one time was that, do we have any kind of antitrust or monopoly issues?
Train of trade.
Yeah, that's right. And I thought one of the discussion points came out was that if TSCPA is providing this low cost quality CPE, then they would by default take the market anyway, because if they're the best price or alternative, then that's where the people are going to go. I know that was a discussion point.
Wendy, did you spoke with Virginia at one time? What is there any update or information you might add to that?
I don't have any recent information. I know that they went back and forth on how they were going to do it, and their approach was different than the approach that we were suggesting, in which they would create the content and then sell it to anybody who was wanting to present it. And that wasn't exactly the avenue. So I have not kept up with exactly how they've implemented that.
Any more discussion?
Are we making a recommendation, Stephen, to the board tomorrow about this decision? Is that what your goal is?
I'm honestly not completely sure, and I guess my personal opinion, I would just make sure that we, legally we can only allow one vendor to do it. I'm not saying we can't. I just don't know what the rule is.
Is the society asking us for? Is this a request by the society, or is this a?
Actually, I'm not interested in a decision being made today or this meeting. I think it's important for us to create the product.
Right.
Work with the staff of the State Board of Accountancy and use the resources that NASA put together. If the State Board, and we can call it the State Board product, it doesn't have to be a TSCP product. We'll be glad to write it, develop it. We'll host it on our website. We can talk about how to cover the cost, recover any costs that we incur on this. But our desire is to put together a first-class product that's consistent and not have 20 different versions, some of whom may recite laws and rules, some may offer some insight on situational, ethical situations that are great learning opportunities for licensees. I've seen this done before. I know it can be done well, and it seems to me to be a logical progression as to the information that we want to present. This should be somewhat black and white. I mean, we've got laws and rules that we want to convey. We don't want licensees to have a position that they are ignorant of the rules or the law. And if we present it to them consistently in a method that they can get 24/7 online, I'm not interested in this being a method of commerce or economic profitability for any one institution. We're not looking at it as a profit center. We're looking at it as a service. And it shouldn't be viewed, in my opinion, that way. I think you offer the CPA exam, for instance. There's one vendor that offers that. You approve that vendor to write it. They charge a fair fee for it. It's been done before. Is there anything different in this? This would be a licensure renewal requirement, and it should be precise, and it should be the gold standard. It should be the best that it can be. Now, I'm no legal authority on this, but it would seem to me that it's nothing more than a licensure renewal requirement. It's really separate from continuing education requirement, in my opinion. I think it's the same as filling out an application or submitting a fee. Completing this requirement necessary to renew your license. Continuing education on your area of specialty, you should be able to choose what's going to benefit you to be a better professional. But in this regard, it's somewhat black and white. And if we're able to get the resources from NASPA, Center for Public Trust, that Alfonso Alexander has indicated is coming our way, and he had identified May 1 as the target date, we can take those resources, put it together in an online fashion, utilizing a state board staff to advise us on precisely what law and rules portion need to be incorporated into this. I just envision that something great can be put together. And I'm not asking for the board to approve anything right now. I think when we just get the product together and get it developed, I think you're going to approve it at least to be one of 20 options. But in my opinion, we should make it good enough to make that be the primary and only sole option for all licensees. Now, if we want to keep it open for others to create their own versions of this, that's up to the board. It doesn't seem to me to be the best way to do it, but there again, if there are legal hurdles that we need to cover, we probably need to do some research on that.
I'm just asking, I know you're not asking for a decision today. Are you saying sometime in the future you might ask that, or?
Absolutely. I
Okay.
think that hopefully by the fall, we'll have the product available for a task force, maybe this committee, to review. The staff can make recommendations on whether or not it should be, and then discuss at that time whether this product that's put together is good enough to be the sole way to obtain this ethics or state law and rules course or whatever we want to call it at the time. But we have a requirement for 2 hours, can easily be put online. And I see some interaction. I see some potential case studies that would relate to law and rules and tie it all together and make it an ethics course specific to Tennessee situations and that would contain law and rule applications. But there again, it hasn't yet been developed, so it's a bit premature, I think, to consider or approve it as a sole opportunity. But if we can do what I think we can get together, we should have a good opportunity to perfect this and not have to deal with 20 or 30 different versions and review them for content. And after we review them, you really never know how they're presented. If they're live, you can look at online stuff. But regardless, that's my plan. That's what we'd like to propose, and hopefully we can get it done this year, get it done soon, so we don't have to kick this can down the road too much longer.
Brad, I think low cost and free are definitely in the best interest of our members. So appreciate y'all pursuing this.
Okay.
Any other comments or discussion points?
This is Charlene. I guess I'm a little confused. I thought at the last meeting that we pretty much said that that we agreed no new state ethics applications would be accepted. I thought we were gonna consider whether we would put some time limit on the ones that were. So I thought we had kind of already addressed that we were moving that direction, but the question was, what do we do with the ones who are already out there? And that was why we asked for the audit of the existing programs. So I just want to make sure we're not reinventing the wheel each time we come together.
I remember talking to some degree about limiting the number, not necessarily sole provider. Did you see that? I don't remember that, but.
So I thought what we were supposed to talk about in this meeting was whether we would have some expiration date on the existing state ethics programs.
What we've just done, or that's what the record, right?
Our recommendation was that we would just implement the quality control review process. We didn't necessarily
But on an annual basis, isn't that what y'all just proposed?
Yeah, but I don't know that we actually specifically said that everybody's application would expire annually. I think they're just reviewing it. If we need to go back and revisit that, then that's something we need to discuss.
At this point, as the rules are written, there is not an expiration date or a approval that gets automatically withdrawn of the sponsors and their education programs. Right now, the rule states approval of any continuing education program may be withdrawn by the board if the sponsor of such program fails to comply with these provisions. That's really the only part of the rule that speaks to withdrawing the approval of one of these programs. So I would ask that you not take at this point any position on whether or not you're going to move forward with one sponsored state-specific education program until I can give you a better legal opinion as to whether or not you have a good basis for doing so. Because right now, it's my understanding that you have 18 providers out there that the board in the history has given approval to, including the ethics program. And we have no indication right now that they are not complying with the standards that you have told them to comply with, as far as in they're offering that ethics program.
Let me ask a question. Is there a problem with us stating that effective June 30, 2016, all courses will have to file for renewal, or some other language? I don't know what the language is, but essentially file for some renewal of the program itself and make them all do it. Nobody's treated differently. And then we start the process. I thought that's kind of where Vic was heading with that. Maybe I misunderstood.
No, all I was trying to do is clean up. There was all this talk about auditing the programs, and so instead of going through and selecting people to audit and then contacting them, just make it a requirement where they've got to send you all the information each year. And if they don't send you the information, then you've got a basis to withdraw them.
Okay, I misunderstood that then.
Yes, sir. Right now, as you pointed out, there is no expiration date. There is no you have to renew your registration. It's that as long as you are in compliance with the standards that you require them to be in compliance with, that approval goes on.
Indefinite.
Yes, sir. And the audit portion that you are approving, that you approved today, are going to ask the board to approve tomorrow, is to give us a basis, to give you a basis to reevaluate and see if those programs that have not been evaluated recently, not been audited, are still in compliance with what they said they were going to do.
Is there a problem with us putting a renewal in place on the existing?
That, I believe, would have to be done by rulemaking.
We're going to be changing the rules anyways, aren't we?
Yeah, it just takes a while. I mean, it's 6 months at least from the time the notice goes out. Excuse me. And so we could be looking at 6 months to a year before that rule could actually change.
They've streamlined things, but it could be as little as, yes, sir, 6 months.
That's not a bad thing. I'm just heads up. That's how much it would take.
But if we don't address it, and it'll be another 6 months.
Exactly. Sure.
I don't know. I'm just throwing that out there. If we want to do something, it seems to me that it seems like we keep coming back to this. There's no expiration. It's indefinite. And we change the rules every year. So it seems like we ought to be evaluating these courses on an annual basis or some period thereof. And I don't know. I mean, I think if you do it to everybody, maybe it's not an undue burden. I mean, we're not singling anybody out, right? I'm not the lawyer here, but
I think there should be some kind of expiration and renewal, or some kind of process like that.
A resubmission of the course material for evaluation.
And you can do that part of it. Say, we need you to resubmit as part of an audit. We're going to look at your materials. As far as saying, if the approval that we've given you so far expires on X date, that is something that, because you're taking away not a license per se, but a right, an obligation that you've already granted to them in the past. That's why I believe the rulemaking would have to kick into play. An audit is different from saying your right to do this stops at a certain date. And I'm happy to draft a rule for you all to look at for that, for the next meeting, to see that, if that's audit process.
Does anybody have a desire to pursue creating an expiration date or a renewal date, period of time that they have to do that?
I don't know. I feel like it makes sense, but I may be on an island here.
I don't disagree with you in the sense, but it seems like that what we really need to do is to wait and see what this product's going to look like that the TSCPA is developing. And then once we can make a decision as to how we want to proceed with that, or even if we want to proceed with that, then we can address how we would deal with all of these people at one time. It seemed like if we're going to put some people to a lot of work, a lot of trouble, if we're going to do away with all the sponsors and just have one provider.
And I'm not suggesting that.
I know. I'm just saying if we establish a cutoff point and require everybody to send in information to us, we're going to put them to a lot of work. If we come along here in the fall or next January and make a decision to go with one sponsor.
My only thought process is to get the rule change started. If it's going to be 6 months anyways, and we can't do that till the next board meeting, which is in July, I believe. Maybe they go ahead and draft the rule. We review the rule in the next meeting, and then we got 6 months before we can pass anything anyways. Hopefully by then the society has their stuff dealt with, but we're not behind the 8 ball in October going another 6 months.
If all we're doing is just
I mean,
looking at and putting forth a change in the rule, then I don't have a problem with that at all.
I mean, assuming the board passes our recommendation to add this quality control measure, it's really not going to be much different if we implemented a expiration date, because they're still going to be submitting the same information in as an application as they are for their audit process. So I mean, it's not like we're going to, even if we did implement a expiration date, it's not really going to affect what they have to send in. So I guess my point is I don't necessarily see the harm of at least getting the ball, implementing this new rule.
And I personally would like to see. I'm sorry, Stephen. I personally like to see two things. One, the draft rule of a potential expiration date on the current folks, and two, the implementation of an annual resubmission of the information, because I think that's a chance that we could end up deciding to go with the annual resubmission without pursuing the expiration date. And that, coupled with what Mr. Floyd says, if this truly is going to be the gold standard for free or very low cost, those two things may take care of itself. We may not have to pursue the expiration piece. But I think it'd be nice to see both of those potential rule changes drafted, and then we could see where we are in July,
Which two? Now, the expiration date, I guess my understanding, the expiration date's the only one that requires a rule change. Is that correct?
Oh, yeah, you may be right. I'm sorry. Maybe the annual resubmission doesn't require a rule change. Is that right?
That would be.
Gotcha. Yeah, I'm sorry. Yeah, good catch. Yeah, okay. Never mind.
Okay. Yeah, but I would agree. I'd like to see the wording for the rule change.
So have we agreed that we're asking the staff to develop a proposal for us on a rule change?
I think we have to send that to the rules committee. Is that not correct? And request that they handle that. Is that a proper procedure?
And can I handle that in the next committee
I was going to say you could probably do it as part of this, as if you make it part of your licensure. Or no, that's not. I'm sorry. I'm off the reservation. I'm sorry.
But can we hold it?
Yes.
We can do it today in the next meeting.
Okay. Good. Do we need any kind of formal recommendation that we send this request to the the Law and Rules Committee?
I don't think so, Stephen.
Okay.
I think that Charlene's here and she'll take care of it.
All righty. Any other discussion or items we need to take care of? Okay. With that said, we will ask for a motion to adjourn.
Second.
All in favor?
Aye.
All opposed? Thank you all. Appreciate it. So I couldn't be there in person, but we will talk to y'all tomorrow.
Thanks, Stephen.
See y'all. Bye-bye.
Rules and policy for clarity and consistency, which my understanding was that we approved it, and I thought we were waiting to get a copy of the ones that we had approved, the changes we approved. Is that correct?
That is what you should have, Madam Chairman, on the iPad.
Ah. Would be under the policy statement revised?
Yes, ma'am.
Okay. Sorry, yes. Good. I think one question I have here is about the rule change dealing with the registered firms number 3. Is that a rule change we need to make? Is that the comment?
I'm sorry, Madam Chairman, I was trying to dispense with your timesheets.
Under number 3, registered firms, number 3 of number 3 registered firms, any non-CPA owner of a CPA firm must work more than 50% of the firm's normal business hours. I was saying it should be addressed by a rule change.
Yes, because I think that's going to be a difficult one to enforce unless you have a rule change implemented. I mean, that's if you want to enforce that policy. I mean, perhaps that's something you want to drop.
Thoughts?
How important is this rule? Because, I mean, if it's got to be a majority-owned CPA firm or CPA-owned firm, right?
Correct.
Do we really care what the other 49% does or doesn't do?
I'm not sure that you do, Trey. This was done back in 2006, and
And I would question why somebody, I mean, if you're going to have a partner, you presume they're going to work and carry their weight to some extent, or they're not really a good partner.
Oh, I think that would be
Yeah,
enforced
I mean,
by the CPA firm.
I just don't know that it matters to me. I don't know. I'd be curious what everybody else thinks.
I'd be more interested in the CPA's time
Right.
devoted to the practice than the non-CPA.
How would we even?
Well,
check that?
what's normal business hours in a CPA firm? I don't know. I mean, I just don't know that I care about this rule.
You know, on the firm registration, we do ask for the percentage of time devoted to the business by the owners. But there again, how do we enforce it? I mean,
But aren't we really just concerned that the CPAs are actually working in the practice and not lending their name to some non-CPA? It seems to me like it's the reverse.
I have thought the
You know what I'm
same
saying?
thing.
I mean, it's like, am I more concerned that some CPA is lending his name to some consultant, and I'm worried he's not spending more than 50% of his time in the business or of the normal business hours, as opposed to what the non-CPA is doing?
right, I agree totally.
There's not a problem with somebody being an owner, but really doesn't work at the firm. I mean, maybe somebody who gave money to the firm and gets some sort of compensation for kind of like a silent partnership.
Startup,
I mean,
seed capital or something.
I don't know if this was intended to get around something like that or if that would even be a problem. I mean, I wouldn't think you'd come across that kind of situation. Probably if you're going to be an owner of an accounting firm, even if you don't have your CPA, you're going to be working there because nobody's going to pay you.
I fall back on the 51% ownership of the CPAs, and do I really even care what the non-CPAs? If we're going to allow 49% ownership to non-CPAs, do I care if he's working there? I mean, I don't know.
We had a case a few months ago, or last year, about this church audit.
Yeah, I
where
remember
one of
that.
the owners didn't work there. We had a.
But we were worried, I think, in that situation because the CPA was not working.
Right.
Well, the CPA was the 51% owner. He did work there.
But he wasn't spending more than 50% of his time in the business, if I remember that correctly.
That's correct.
This is only addressing the non-CPA.
There was a non-CPA. It seemed like there was a non-CPA
There was.
that didn't have any.
But see, there, I think what was happening was the CPA was trying to lend his name to
Non-CPA.
a non-CPA so that he could get registered.
Right.
It's not, we were worried about what the CPA was doing. We weren't worried about what the non-CPA was doing. Or let me say that differently. That's not accurate. We were worried about what the non-CPA was doing. But my point was, I don't think we would have cared if he worked less than 50% in that business.
Right. As long as he works something.
I think the problem is if you say you're a 51% owner and you're not spending more than 50% of the normal business hours in the firm, what is that the appearance that this is some sort of false setup? Not the vice versa, or I'm not doing a good job explaining myself today, but I don't think I care.
I'm in agreement. I'm more worried about the CPA owner's activities.
Then I think we should just omit this policy altogether. And someone?
I'm in favor of that. I'll make a motion to that effect.
Go ahead.
I make a motion that we abolish under registered firms number 3 as a rule.
Second.
Second.
All in favor?
Aye.
Aye. Anyone see anything else in here that we might want to change? Or
A question.
Okay.
And there are 2 typos. I didn't read this necessarily with an eye towards typos, but 2 things jumped out. I'll give it to you just so that it can be corrected. I'm sure somebody will go through and read it with an eye towards typos. Under section 2, number 4, board under Tennessee State Board of Accountancy needs to be capitalized. And then under section 3, number 2, in the last sentence, there's a period in the middle of a sentence. It shall be period forwarded. That period should be removed. And then my question was, under 4, enforcement, it says that this rule was amended May 1st, 2015. And I was confused about that date since we haven't had that meeting. I didn't know if that was supposed to be, I know we talked about this issue, I believe, at our last meeting. I didn't know if that was supposed to be that date or.
No, I think that I was anticipating the board's final approval of the policy changes.
Okay.
Board meeting tomorrow.
Policy statement
So you're going to
changes.
put these on all of them, or May 1st on all of these?
That are any sections that I've amended.
Oh,
Or
okay.
you've amended.
Okay. That's all. That was my only question.
we don't need to make a motion on the change on the
We have to accept it.
spelling. Yeah. I meant on the.
On the spelling.
Typos.
Okay,
No.
typos, okay. Then, do we need to make an acceptance, assuming this correction, and then one more approval at one more read through at the next meeting? Has legal looked at it yet? Is that where we are?
I have looked at it. I think that you just need to make a motion to approve as revised.
I'll make a motion that we approve as revised.
Second.
All in favor?
Aye.
Aye.
Great. Okay. So we do have a new business agenda item that we are going to, it's been brought to us from the licensing committee that we should ask for a wording by legal on a potential expiration date for the current CPE registered for companies.
State specific.
State specific.
There we go.
Thank you. Would someone like to put together
To make sure I understand. So basically, we're requesting legal to put together a draft rule change that would
Address the
expiration
expiration
date.
of. You want me,
Sorry,
I'll make
I
it.
forgot you weren't here.
I actually was sitting out there. I heard
Okay.
this part. So I was
Okay.
I'll just make the motion that we authorize the staff attorney to draft a rule modification for our review at the next board meeting to address the expiration dates of Tennessee specific ethics courses.
Here, a second.
Second that.
Is there a discussion? All in favor?
Aye.
Is there any more new business or old business that we should attend to? Someone like to recommend adjourning or so moved.
Second.
Approved.
Approved. There we go.
Thank you.
And we're back on schedule.
All right.
We call ourselves now the Enforcement Committee to order. I've been asked to chair it in Casey's absence today. I'm Don Royston, and it's 3:30 or 2:30 this time. If you would take a moment, and it'll take more than a few moments for those of you that I know that was mailed out to you, members of the committee, or emailed to you previously. Have you had a chance to look at it and go over the report? And I don't want to belabor it because there's a lot of them in there. We got close to 50 cases that we're going to do something with. We need some time to look over it. Are you happy that we can proceed? Sounds like we're ready to go. Okay, the first section, particularly 1 through 9, relate to recommended dismissals. Does anybody have any questions about any of those that we need to ask our investigators or legal counsel? If not, I would entertain a motion to accept their recommendation.
So moved.
I have a motion. Do I have a second? I have a second, Ms. Brundage. Thank you. That handles cases 1 through 9. 10 and 11.
Question, if you don't mind, can you take a vote on that? A committee vote?
Yes. Thank you. All in favor of the motion signify by saying aye.
Aye.
Opposed, like sign. Motion passes. 10 and 11 are recommended cease and desist letters. Both are finally fairly minor in problem areas. Anybody have any questions for our investigators or the legal counsel? I'd accept a motion to approve.
So moved.
Thank you.
Second.
Thank you. All in favor of the motion signify by saying aye.
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 Opposed, like sign. Motion carries. Recommended letters of warning, items 12 through 27. There's a lot of different areas in this thing. Are there any particular questions as you look down the list on particular items? Do any of the investigators want to add anything to any of the explanations on these? Feel free to jump in. We've got a paragraph. You all got the files. On 15, I have a question. Where was the primary license on 15?
Tennessee.
Okay.
Like a little explanation? A small one.
Okay, a small one.
Okay. The Kansas license was obtained because the firm was expanding and opened a firm in Kansas. Under Kansas law, there must be a CPA there. So to help out, in addition to the resident CPA Kansas person, this individual obtained a Kansas CPA license. And subsequent to all that, had it revoked over a CPE issue.
when staff on the other end failed to forward the certified letters informing him that he'd been chosen and then subsequently revoked. So.
Very good. Thank you. On 16 and 17, are we keeping these in monitoring status, or are you all, what processes we got? Because there's several down here in this whole pack with 20 and 21 that say close with a letter of warning, but are we going to do something if their licenses are not reinstated? Says they're applying for in the process of. Are we dismissing a complaint or closing the barn doors after the horse is already out?
The letter of warning acts as notice to them that if they don't follow through with what they have promised the board they're going to do, that we will move forward with disciplinary action. Yes, sir.
Thank you. That clears up several questions on my part. Further questions from anybody on the committee? I'd entertain a motion for approval of their recommendations for forwarding to the board tomorrow.
So moved.
This is going through 27, starting with number 10. No, excuse me, starting with number 12. The recommended letters of warning. I've got a motion and a second. All in favor signify by saying aye.
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 Opposed, like sign. Motion carries. Recommended consent orders. These are a little more detailed. Going through number 45, 28 through 45. Questions on individual cases or comments by investigators or board staff?
Could you refresh my memory on 28? It's like this has come before us once before.
Yes, sir, it has. As you can see from the date of the complaint, it's a 2009 case. It came before the board back in, I believe it was 2012. And I've placed in the legal report there the recommendation that was made. This was an alleged embezzlement on behalf of the respondent from the company that he worked for. He was eventually terminated. There was a lawsuit that was dismissed. After that happened, the respondent countersued the employer for wrongful termination based on essentially some employment benefits that he had been promised and had become vested while he was an employer or employee of this firm. They recently reached an out-of-court settlement that has not yet been finalized, and so that is why I have included there that even though they have reached some terms in their settlement, the board itself is not bound by what they have agreed to or are hoping the board to do. What the respondent's attorney was asking for is a much less term of revocation and no civil penalty based on what you had previously authorized back in 2012. And in speaking with the executive director, I didn't think that that was necessarily appropriate based on the scope of what the investigation showed. And so that is why I recommended what I did, which is still a substantial civil penalty and the revocation for 5 years.
So it was never, the lawsuit about the embezzlement was dismissed, right?
Yes.
So,
But the insurance company paid.
Right.
After hiring their own accountants to come in and investigate.
I noted in the legal report, and I would just point out to you now that the civil suit against the respondent for that embezzlement by his former employer was dismissed on a technical basis. There was no finding as to the facts of the case itself. So that issue was never reached.
You're still recommending 5 years, and that was what was originally recommended?
Yes, sir.
They asked for a lesser period than that, though?
Yes,
okay. All right. Thank you.
We've had the full discussion on that one, and it is a large penalty and disciplinary action. May I ask for a motion on 28 by itself, approving the, or a motion period?
So move.
So moved, and that's for approval of the
For approval.
recommendation. Thank you. Do I have a second?
Second.
I have a second. All in favor of the motion signify by saying aye.
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 Opposed, like sign. Motion carries. Other questions? We're down, taking 29 through 45 still.
29, I'm just, so 29 is a separate case, it appears. Is that correct?
From 28?
Yes.
Yes, sir. It's a different respondent.
So can we, I mean, it's pretty limited on what it's telling us. It appears there's 3 actions, is that true?
Yes, sir.
So acts discreditable, practicing on an expired license, and failed to respond to complaints. Is that what those 3 actions are?
Yes, sir.
What are,
I'm sorry, and failure to return client books and records.
and what are the alleged acts discreditable?
I kind of used it as an umbrella for the overall issues with this particular person, which included closing their office and abandoning their clients as a whole. Only 3 actually filed complaints, but we had innumerable others who had been left out in the cold with no access to their books and records. Also, I guess the act discreditable was more in the lack of finishing the preparation of their individual and corporate tax returns. Kind of where I kind of went in with that. And of course, failure to not only to respond to us and any kind of written response, but also failure to respond to their client's requests for information.
Number 30. Being 32, and there's a couple of them down here, but one answer will probably cover most of them. What about the recommendation says a formal hearing for revocation with authority to settle with the payment of $1,000? Does that mean if they pay the $1,000, we're not going to revoke the license?
Correct. Yes, sir. The reason that it is worded that way is that the ability to settle on the payment of a civil penalty will end the case. If they choose to go forward with a formal hearing and contest the discipline or contest the facts, when the litigator presents the case before the board, it gives the litigator the option of asking the board for the civil penalty all the way up to revocation. It just kind of opens the options if, for whatever reason, we do have to go forward with a formal hearing.
Thank you.
Yes, sir.
Good explanation.
A question on this, and maybe a dumb question. I'm not an accountant here practicing, but
Got to be trying to understand law and not being a lawyer.
So the person's offering services on a retired license, and we revoke a retired license. Is there any disincentive for that person to stop what they're doing? I mean, I understand that technically there's a difference between a revoked license or suspended license and a license is retired status. But the idea is that in all 3 situations, they're potentially offering services without an active license, right? So if they pay the fine, then what's going to stop them from, I mean, just because they don't want another fine? Is that what it is? I guess I'm trying to understand.
No, what will stop them is that as part of the consent order that they sign when they pay the fine, they are agreeing to cease and desist all further activity like whatever got them into the position that they're in. Once I have that consent order, it is a binding order on that respondent, and if they continue to perform the unlicensed activity, the Attorney General's office can then take that final order to a court and get an injunction against the respondent.
That's helpful. Thank you.
Yes, sir.
Thank you. Any other further questions? Let's see.
I have a question on 33.
33? Yes, ma'am.
I just want to make sure that one, we're dealing with professional privilege taxes that weren't timely paid, that subsequently have been paid, I believe, and recommended a civil penalty of $1,000. And later, like on number 38, it was a similar situation, slightly different facts, for a $100 civil penalty. Was the difference there because on 33, it looks like the respondent failed to respond to the complaint, and on these other ones where they only have to pay $500, it's maybe because they did respond?
In this particular respondent's situation, number 33, it was that they had a prior complaint for the same thing.
Okay.
So that's why it's 1,000 and
Okay.
not 500. Usually, and correct me if I'm wrong, Director, but if no prior history of that activity, we start with the $500 civil penalty.
Okay, thank you.
Yes, ma'am.
Number 40, do we know where the respondent hasn't responded, so whatever they're called, the non-respondent, do we know where they're located to get their license back?
I don't know where they are. Their last known address was out of the country.
Enough said. Thank you.
Called all the numbers listed.
Assume we have access to, we've got Facebook, yeah, but that's a good point. Maybe we used Facebook yet?
Sometimes.
Do we have access to legal paid databases, I assume, for searching for people?
Yes, that's where I got probably 4, 5, maybe 6 telephone numbers to go through, and they were either disconnected or he wasn't there.
Thank you very much. Any further questions regarding items up through 45, starting with 29 through 45? Hearing none, do I have a motion for accepting the recommendation of our legal department and investigators for approval?
So moved.
Second.
Second.
Thank you. All in favor say aye.
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 Opposed, like sign. Motion carries. Last 4 are recommended to be moved into litigation monitoring status. I think everybody on the boards, on the committee here, is aware of that and seen it before, where they're just going to continue monitoring it until litigation is settled and that we have all the facts and can act. Do we have any questions on those 4? I'd entertain a motion for approval.
Move.
Second.
I have a motion and a second. All in favor signify by saying aye.
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 Opposed, like sign. Do we have any new business that needs to be handled in our committee? Hearing none, I'd entertain a motion for dismissal. Yes, sir. Oh, excuse me. That beautiful. I'm sorry, Mr. Mills. Would you
that's
make
quite
your
all right.
Since you've developed that nice tool, would you present it to us, please?
Well, with the help of Miss Karen Condon, if I could actually get it to call up now, it would be wonderful. Oh,
It's what
yeah,
happens when you use paper instead of the stuff they,
my
instead of
first
putting
mistake, yes, I'm sorry. Okay, if you look at our open complaints for the year ended and also for the quarter ended, you can see that we're up as far as our load that we're carrying at 117 cases. 77 of those in legal, but if you also note, you just approved, 49 of those to be disposed of. So we're just clicking right along. Other than that, nothing really out of the ordinary. We do have, Karen has compiled some statistics which we'll put in next time. In addition to your graph there, which the pie chart, which I really love, kind of gives you an idea of where things are. But she has updated our 5 to 6 year data on number of complaints, disposition of complaints, and all the summaries therein. So we're starting to use those in our ethics presentations to the licensees, and I thought the other day that you would probably like to see those slides as well. So we're going to include those next time. Any questions? I'm here all day.
So she. If we want the real answer.
And you want the real answer, yeah.
Thank you, Mr. Mills and Karen. Good job on both of them.
Can I ask a question? In your review of all these P10 numbers, you've uncovered a lot of CPAs. Maybe a lot's not the right word, but several CPAs that are in a retired status, but they're out there practicing. They're out there doing something. Have you gotten pretty well cooperation from the CPAs to get back in compliant with their license?
I have not had a specific retirees. I think there's some out there.
We had a letter at the last meeting. There was a letter from a CPA in Chattanooga who wrote to the board about the fact that he was retired and that he was doing some tax returns for his old firm. And that type of situation is what I was talking about.
Well, I think one of the things that came up, I'm sorry, Ray. One of the things that came up is that the new rule that was enacted, year before last, where if you're retired or closed or whatever, you go work for a CPA firm, as long as you don't use your designation, you can go back to your firm or any accounting firm and perform accounting services. You just can't sign. And I think we were finding that to be a lot more prevalent than we had anticipated. These people are going in, say a retired partner, for instance, coming back in April. I had one gentleman who was going all the way back to Georgia and doing tax returns at his old firm, but he wasn't doing any in Tennessee. So, but I haven't had a lot, right?
The main violation that I found in them was people who moved here and thought just because they had a license in another state they could do tax returns here. That was where I found most of the problem. And I think our coordinator wrote letters to some of them that were retired, and they must have gotten straightened out because they never came to Don and I as a complaint.
It was my understanding that if a CPA had retired his license and he had gone to a retired status with his license, that he could not do any kind of work preparing tax returns. And if he was working for his old firm preparing tax returns, he was going to have to get his license brought back into compliance.
As long as he doesn't sign them, isn't that correct?
Is it signing or holding out?
The jury's still out.
As long as he doesn't sign them, right, Mark? He can prepare the return.
Have we changed our policy on that? Because I understood at our last meeting that they couldn't do anything.
As long as he doesn't hold out.
How does he keep
You
from
can
not
put him in
holding?
the back room
How
doing
does
returns
how does he keep from not holding out?
because he doesn't sign the return. He just puts.
But if he
just
meets
puts
with the
numbers on
client,
paper.
if he meets with the taxpayer at all,
He wouldn't.
how do you stop that?
I worked for somebody who was, now I was compliant, but I never signed a thing and I never met with any of his clients. I just did returns.
Mm-hmm.
And he did all the rest.
Well, I'm not saying that there couldn't be situations like that. I'm just asking.
Kept me in the back room, so.
I've had several questions come up about that issue, and it was my understanding that they couldn't even come in and work in the back room. They couldn't do anything.
They've been asserting under this subsection, whatever it is,
It's
that as long as they don't hold out, sign the tax return.
20-05-03.
Holding out would include displaying a retired wall certificate, business cards, etc., an email, that
I think it would
you're
include
Joe
anything.
Jones, not Joe
yeah.
Jones CPA.
The same as if you were a non-licensee, that the criteria. Now, can we prove it? I don't know. I've got one active right now that was just given to me by legal that is a retiree or an inactive. They're both really the same if you look at the restrictions. Working for a firm. And we're going to have to make a determination at some point. What can we prove? What can't we prove? If you sign an affidavit and you tell me you're not meeting with clients and you're not signing returns, do I trust you? Or do I whip out a return that's got your name on it?
We've had a number of people that had their license in a retired status, and because of this position that we took, have come back to the
Activated.
board and asked to have their license reinstated,
Well, just reactivated, yeah.
reactivated.
Yeah. But this latest rule change gives them a little wiggle room on that last paragraph, which Mark will read to you.
Yeah. That rule has not yet been placed into effective status, Henry.
I'm sorry?
That rule has not yet been placed in effective status. As far as we can tell, it is not posted on the Secretary of State's website as part of our rules. So it's something you all passed and has been approved, but it hasn't made it to the actual rule book yet. Pardon?
Published?
No, it hasn't been published.
Would you mind reading the rule to us?
Mark, along with reading the rule to it, if you could tell us where we are as we're handling cases right now and where we're going to be based on the rule change, so that we're not, trying to fix something now that's being fixed with the rule because it hasn't been published.
Right. Okay, if you'll look in rule number 0020-05-.03. And then down there under subsection 3 is where it's talking about activities of inactive licensees.
Happen to have a page number on there, would you?
Page number 2 in section 5 of the rules. And if you look under section 3D, it says a certificate holder who has been granted inactive status may perform the services set forth in C above if The services are provided without compensation to the certificate holder. The services are performed solely for the certificate holder's employer, and such employer is not a licensed accounting firm, or the certificate holder does not use the CPA or PA designation in association with his or her name while providing such lawful services.
Give me that reference again.
It's 0020-05-.03, subsection 3D. And the services it's talking about is set forth in section C. It says, a certificate holder who has been granted inactive status may not for compensation perform or offer to perform for the public, including the providing of any accounting service from a licensed accounting firm, any of the following services: any accounting or auditing service which involves the issuance of reports on financial statements, including opinions, reviews, compilations, or attest engagements; any consulting engagement which would constitute the attest function, or furnishing advice on tax matters. Does that answer your question?
Probably does.
Very definitive.
Okay. Now, let me just.
Any other questions
that up a
or
little
business for this committee?
Quick question. Can y'all explain the pretty dramatic increase in legal investigations from July of last year of like 12 to 77 now? Is it because we're having more success proactively going after things like professional privilege taxes or the PTIN stuff, or is it just not really explainable in terms of, some trend that we're doing?
By analysis would indicate it's PTIN oriented.
Further questions? Hearing none, I would entertain a motion for adjournment.
So moved.
Second. Consider yourself adjourned. Thank you.
If I stay here for the executive committee, y'all talk about something I want to talk about. Can I talk? Like the third person that's told me that. It's like, yeah, so.
First one is.
Yeah.
Yeah, right. Call the executive committee meeting to order. The first item is a review of financial results. Mark?
You have the operating results there on your iPad. You should have received them prior to now. Last week, I think, when the board information went out. The only thing I would point out to you there is a notification that, of course, our revenues are down some, but we expected that because of the fee decrease. You have an analysis of February 14 versus February 15. It's down 4.9%. It's not bad. We still have about 192 delinquent licensees out there that have not yet renewed their license. And I think we have 2 delinquent firms, so it's not a whole lot of money that's still remaining. So most of our money is going to be coming from applications in the future. There are no big surprises anywhere else. I would point out that our travel is a little bit down from last year, and that is due to my not traveling so much with the Executive Directors Committee. I was pleased that we were able to take some of our board members to the NASBA annual meeting in October, and hope to take several to the NASBA Eastern Regional in June. We have the money allocated for that. If you look at communications and shipping, that is down 22%. That is largely due to our decision to do the newsletter in an electronic format as opposed to mailing it out. So we did that this year, and it seemed to be very successful. Other than that, Mr. Chairman, I don't have any observations. Do you have any questions?
Any questions from the committee or other board members?
Just a quick question. I'm sorry, Henry.
Go ahead.
On the cost of core, remind me, I know we talk about this every single time we meet, but quarterly I forget. Are we going to get additional charges above and beyond the 70?
Yes, there will be some additional charges. They should not nearly be as significant as that $70,000.
Okay. I seem to remember $20-some-odd thousand somewhere,
You know,
but
there's going to be some more charges.
Okay.
Why did you say our revenues were down?
Because we decreased the fees from $120 to $110 for biennial renewals. This is the first year that went into effect.
So are you saying that the number of licensees hasn't changed?
Correct.
Okay.
Okay. Do you want to speak to us regarding the travel?
Here again, I think the reports kind of speak for themselves. You have one for Mr. Butler, one for myself, and one for Mr. Mills. Mine includes the days out of office as requested by the chairman. There are no, here again, there are no significant surprises here. 10 days out of office in the quarter for me. And of course, Don and Ray have their investigations that take up a good bit of their money for the travel. I will say that Ms. Cooper also attended the legal conference when we went to Tampa, and hers will be charged to our account. But here again, that's something for which we budgeted and should not be a surprise when that actually hits the books.
So why did it take $800 more for Ray Butler to go to Tampa than Don Mill?
I included the registration fee in it.
I didn't. I just put down
And you
travel.
absorbed it personally.
I was not reimbursed for it, so I didn't recognize it.
Okay, and then you have, I thought I saw plane travel.
Plane travel?
Or the travel for, don't you most times send us, give us information regarding the travel that you plan to do in the next several months?
Planned travel.
Planned,
Yes,
not
sir. That'll
planned.
be on your executive director's report tomorrow.
Okay. Okay, yeah, it's already, okay, I knew I'd seen it someplace, okay. Any other questions regarding travel? If not, we move on to the discussion of complaints against non-registered professional service firms, better known as the H&R Block issue. Tony, you want to introduce yourself and
Thank you. My name is Tony Glandorf. I'm the Chief Counsel for the Regulatory Boards Division. I'm the Chief Counsel for all of the 23 different boards and commissions that we have here. I'm here today to assist in answering the board's questions and concerns regarding non-licensed persons who are conducting tax preparation work and licensed persons at firms non-licensed firms such as H&R Block. I was not here at the January meeting, but I did watch the video, I believe, for the 2 days and the discussions that you all had regarding this issue. And I'm here today to give you all some legal guidance regarding that. In summary, I've looked over the statutes and rules regarding this issue, and I did come across that it appeared that Michael Driver back in 2008 had provided some guidance regarding this issue. So we use that as basically a guide going forward in our analysis, but I can't find anything in your statutes or rules that would indicate that any person conducting tax preparation services would be required to be registered as a CPA, nor that any firm, unlicensed firm such as H&R Block, that would employ a person to do tax preparation services, whether or not that person is currently licensed or registered as a CPA or not to actually be required to be licensed, registered as a firm in this state. That's in summary. I can give you all some more detail if you would like, because I think there's a rule that provides a little bit of confusion as to why that is, and I can point that out.
Could I ask a question? Would you mind outlining the issue?
Yeah, the issue that
I just want to get clear on that first.
right, and I can only tell you the issue from what I saw on the videotape. I wasn't here in January, but it appeared that it seems like there were several categories of issues, and one of those issues were, is a CPA allowed to work at H&R Block and perform tax preparation services with H&R Block not registered as a firm? That was one of the questions that I saw. And are they required? And no, I do not think that H&R Block is required to be registered as a firm to do tax preparation services, because it is not a test services. And a CPA working at H&R Block is not required to be, that a CPA working at someplace such as, and this is all just an example, as H&R Block can do so, even though H&R Block is not registered as a firm, because from reading the statute, in order, a CPA license is only required to do attest services. And tax preparation services is not attest services.
I thought that our definition of accounting for the license included tax preparation services.
You have a definition of the word accounting, which says, and that's in 0200-01-.01, accounting services means accounting, attest, tax, consulting, or management advisory services. But nothing in the statute or rules indicate that any person conducting accounting services must be registered as a CPA.
I don't think we were, what we're saying, that's not the issue. The issue is that I'm a retired CPA. I've let everything lapse. I'm still holding myself out as a CPA, working for a tax preparation firm that is not a CPA firm, not a registered firm. I thought our approach was that maybe H&R Block doesn't have to be licensed as a firm, but the individual that's holding himself out as a CPA is doing accounting services by definition, and therefore he has to register as a CPA firm and work there, so that we've got some method of monitoring for the public the work that's being done.
I don't see anything in the rule that says anybody conducting accounting services has to be registered as a CPA firm either.
So they can't work for an unregistered firm.
An individual.
An individual. A CPA cannot work for an unregistered firm. Is that not the rule?
And a CPA is only required to be a CPA to do attest services.
No, to do accounting services.
No, I don't read that in the law.
Mark, what do you see in the law?
Well, I would respectfully say that whatever advice Mark Crocker would give you, he cannot give you legal advice.
I'm not asking him for legal advice.
Just to clarify.
The way it's been interpreted in past, Trey, is there is a, let me find it. Under Rule 0020-01-.11, where it says each CPA and/or PA firm providing accounting services or engaged in the practice of public accountancy in this state as a sole proprietorship, partnership, or corporation of certified public accountants and/or public accountants shall obtain a permit from the board for each office location for the ensuing calendar year.
What's your interpretation of that?
My interpretation of that rule is that a CPA or CPA firm, not a CPA individual person, has a registration. A CPA or CPA firm, by definition, CPA and CPA firm means they have a license. In order to
Do you not have something in our rules that states that a CPA cannot work for an unregistered firm? We do not.
We've relied on this in the past.
Okay, I stand corrected then.
Could you tell me the rule again, Mark?
0020-.01-.11, Section 1.
Zero zero 20-02.
-01.11.
So one of the nuances at the last board meeting was, Mr. Chairman, sorry, can I talk? I'm not on the committee.
Please.
Was that it's once you go to the trouble of becoming a licensed CPA, then you want to try to provide tax services, which might otherwise not require you to have a CPA license. That's where the issue is, which then gets into the issue of whether you have a retired status license or inactive license or whatever.
My understanding is I could, if I wanted to do tax preparation, I could do that. Well, regardless if I'm an attorney or not, but other persons that are working there, you don't have to have any kind of license to do that.
So I'm trying to narrow the
Yes.
scope to, we're not talking about that issue. We're talking about the people who have gone to the trouble of becoming a CPA, whether they're required to or not. They now have the license and are therefore under the purview of the board. The question is does that change the analysis at all? If those individuals then go provide services, whether they require a CPA license or not, to a firm that is unregistered.
No, I don't think so, and this is the example that I give. I could take that same example and say, would you try to hold that same standard to a CPA who holds himself out to change tires for a living, tire services?
Well, I think there's probably, I understand your nuance, and I'm not saying I disagree with you. I'm just trying to tease it out for the board. I think that's a completely different and probably not an applicable analogy, because a tire service is not something that could be construed to become an attest or an accounting service to someone who doesn't understand, to a lay person who doesn't understand the difference. But I think if you're a CPA, a licensed CPA, and you're at a firm that's providing some type of financial services, my opinion would be that it would be easy to confuse a layperson as to whether or not you are required to have a license or not. Is that kind of understanding where we were at the last board meeting on this issue? I think so. So within that construct, is that a problem or not?
I don't, the way that I look at the issue is it appears that I don't see how that's harmful to the public, because it seems like if you are a CPA doing tax preparation services, you're actually, the person who's paying you to do that is getting a better bang for their buck than a layperson.
Which is a point I made at the last meeting, but I thought we had an issue that there was a technical problem with that, because the person went through the trouble of becoming licensed, and thereby there was some technical issue that they would then be prohibited from providing services to an unlicensed firm, or on behalf of an unlicensed firm.
Well, yeah, and I think that gets back to for the technicalities of it, is that a CPA license is that registration, it's only required for someone performing the attest service, and that's where the tax preparation, to my knowledge, doesn't fall into that. So it's,
What do our rules say?
the rule right here that we just read says that a CPA or PA firm who's providing accounting services has to have a license at each individual location that it has.
Okay, but what about the definitions that are in part of our law and rules? And I'm asking technical out there again, because, you know, I've been on the board for 7 years now, and this is you're the first attorney that has ever given us any legal advice other than the fact that it says accounting is accounting is the same as tax preparation, because that's where we're licensed to protect the public. We're held to a higher standard than somebody that goes to a 2-day tax prep school.
Right, and that's not how
And we can't, if we can't look at them as such, then how are we going to protect them?
Right, well,
If your definition is that tax is not part of what we're enforcing, then I mean, why's the board trying to regulate it?
well, that's what, I think maybe the bottom line is I don't see why the board would want to regulate tax preparation services when it's not in the statutory scheme. I don't see that it's in the statutory scheme that the legislature ever intended the board to regulate tax preparation services.
Only of our members now, our licensed members, not tax preparation services generically.
Right.
It's the people that are holding themselves out to be CPAs.
Yeah. Well, there's nothing in the statute that is in regards to what a CPA does that has anything to do with tax preparation services that I can see. It's attest services.
Right. So I think Mr.
That's
Royson's
not
point.
what's been hammered in my head over the last 50 years that I've practiced.
Actually, Mr. Royson's point is really good. I mean, the idea is that we're regulating the behavior of those who we license. And so I think that's what Mr. Royson is getting at, is that while we're not trying to regulate tax services, we are required and charged to regulate the services and behavior of individuals who have a license that we bestowed upon them. And I think that's kind of, again, a nuance that's important to us to tease out.
Right.
And the annual renewal of our license, or the semi-annual, you have to have X number of hours in the mix of tax.
I think that if this board had the authority to regulate a CPA and who they have to work for when they're doing tax preparation services, the legislature would have given you also the authority to regulate those persons who are not licensed.
I don't know.
I can't. Well, you're
Meaning
you're
that,
legal counsel. I realize that.
well, yeah. Well, meaning that if you were at a non-registered firm like H&R Block and someone's sitting here and they're a CPA, and then there's a non-CPA and you say, CPA, you can't sit there. You cannot do this function because you have to do it out of a registered CPA firm.
Or your own registered CPA
Right, or your
firm.
own registered CPA firm. But there's no protection in the public in that, because if you take him out of the mix, then all these persons from the public are allowed to, and we all agree, that they can come and have their taxes done by persons who aren't CPAs and by unregistered firms.
But they're
So
not
you-
holding themselves out to be CPAs.
That
That's
CPA,
like
if
an
the
unlicensed doctor.
Yeah.
By the same token, what's to keep a doctor from, practicing without a license?
Well, in that scenario, in the scenario, I don't know if there's a similar scenario that we could think of, but the CPA, when they're sitting there doing tax preparation services, they're not performing any function which they're required to be licensed for. You're not required
If
to be
it's a
licensed.
CPA in the state of Tennessee, they are.
No, I just said earlier, sir, that's my opinion that they don't.
So I think that goes to the question of this rule, or it sounds to me like if what your opinion is that, then that means that this rule is invalid or is contrary to the statute. I mean, the statute controls. Because the way I read the rule, it says I'm not trying to put you through the paces, I'm just trying to figure out how we get to where we are. Because it says each CPA providing, quote, accounting services are required to have a permit or a license by the board.
CPA, PA firm, and or
Well,
PA
it says
firm.
each CPA and or PA firm. So it could be read as or, right?
Well, it could be, here's how I read it. It's either each CPA firm and PA firm, or each CPA firm or PA firm.
See, I think the and or between CPA and PA, this is like a very nerdy legal argument. I understand that. I think the fact that the placement of the and ors between CPA and PA rather than firm, I think it's talking about the modifiers. It seems to me like it could be a CPA or it could be a CPA firm. It sounds like you're saying that it means CPA firm or PA firm. Is that right?
That's how I read it.
Okay. I think another reasonable way to read it is that each CPA and or firm.
Well, because when I read the sentence, I read it in its totality, which if you continue to reading it, it's regarding providing accounting services in this state as a sole proprietorship partnership corporation. And it basically says, and or public accountants, it's a mandate. The mandate is shall obtain a permit from the board for each office location for the ensuing calendar year. So it's basically indicating that if you have more than one location in which you're doing business, you have to have a license for each location. It does not say you shall not provide some sort of function. It's basic, and the title of the rule is application and renewal of CPA and PA firm permits.
Right, so I mean, I guess what I'm saying is because it includes the word sole proprietorship in the rest of the sentence, a single CPA could operate as a sole proprietor. I mean, by definition, a sole proprietorship is a single CPA.
Right, and that would have to be as a firm.
I'm saying that I totally understand what you're saying, and I don't disagree with what you're saying. It just seems to me there's also another as reasonable interpretation, which I think we need to provide clarity on, regardless of what happens.
And that's what I'm trying to give you clarity on, is that's my reading of how the rule, that's my interpretation of how the rule should be read.
So your instruction to the board is for us to rely on the fact that the and or means CPA firm and or PA firm.
That's correct.
Okay.
Could I expand the question a little bit? Back to the definition of accounting services. Rule 0020-01-.011B accounting services means accounting, attest, tax, consulting, or management advisory services. If we take what we've tried to apply in the case of a CPA working for a tax service firm, that would apply to the same, the rationale would apply to a CPA working for a McKinsey or a Booz Allen. I mean, it says consulting or management advisory services. We're basically saying that a CPA can't work for an unregistered firm unless they have a permit themselves.
Or was it, I'm sorry, sir. I missed the
What
question.
I'm hearing you say is
Okay.
that it is not wrong for a CPA to work for H&R Block or Hewitt, Jackson Hewitt or whoever. Neither would it be wrong for a CPA to work for a consulting firm that's not registered, just like the tax service firm.
You're correct. I don't think they would require to be licensed to do that either, so long as they're not performing a test services.
Right.
My understanding of, my reading of the CPA credential allows you to do a test service or a test work.
What if they're signing their name to documents, either tax returns or consulting documents, with CPA on there?
Well, I think
John Doe CPA.
Right. Well, I don't think that that's certifying that he's doing it, that he's done a test work. I think the CPA is the licensure what they have, and I don't think it's germane as to whether or not CPA is next to it. Because it's not a test service, so it's not as if he performed that tax preparation work within some national, international standard. He just filled out the form.
There's a little more to it than just filling out the form.
that.
There's education and certifications and annual renewals to keep your certification. It's just like passing the bar exam. You have to have certain CLE requirements, and they have to be, by categories to maintain your areas of practice. And I don't, American Institute of CPAs that we're all under the umbrella of, they set out guidance for tax as well. That's all part of the license. You have a separate section for tax. You're certified in tax. You're not just certified in a test.
Is that considered to be a test services?
What, tax?
Tax.
No, sir, it's not.
Right. And see, that's where the statute says that you have to have a CPA, you have to be a CPA in order to do a test services, and that's all.
Again, I think I'm sorry, go ahead, Mr. Chairman.
So
We have no oversight. Essentially, we have no oversight of H&R Block, is what he's saying.
Well, that's not
right.
H&R Block's not who we're trying to oversight.
I understand that, but we're
It's
trying to
our
get back.
individuals.
But it's the people that are working there. So if something goes wrong, are we going to be able to do anything?
Apparently not.
That's what I'm getting at.
Well, you all have, my understanding is that you all have some rules on disciplinary functions if to their standard of work issues or whatnot. I mean, but that would have to be looked at as to exactly what they're doing. I don't know if it has to do with the tax preparation, but, I mean.
That applies whether they work as a CFO for a company or in all kinds of other occupations other than working for a CPA firm.
I mean, they could be performing in other capacities or whatnot, but and if I could, I'll go through. I did some work over the last couple months that I'd like to let you all know about, if I could, if maybe we could just pause the discussion. But
can I ask a question?
Yes, absolutely.
Is it the administration's point that we cannot do anything about this?
Meaning,
if you're coming here as legal counsel, I'm just
sir.
going to say what I'm thinking here. Do we really need to go through this if your point is we cannot do what we had talked about doing before? I don't know that I want to go through the process of doing all this if the discussion isn't really going to lead anywhere anyways. Am I making myself clear?
I understand and agree with that. I guess, has any other state board of accountancy encountered this or challenged this question regarding tax preparation services? Are we out there alone? Mark?
This is something the other states have struggled with in the past. No one has taken it on to the proportion that we have. I'll put it that way.
Did we take it on in,
We took it on in good faith after the board's meeting last time, instructing us that if you were a CPA working out of an unregistered firm, that you needed to form your own firm and contract with the unregistered firm.
I mean, my whole point is if we're at a point where our own in-house legal counsel is telling us we can't do what we talked about doing.
We can't make them register because we have no authority to have it.
Right.
What I'm hearing.
So what's,
well, but the
If I could-
individual, if he wants to stay registered as a CPA, he could do that.
right?
But he just, are you saying, but he can work for H&R Block or whoever he wants to?
That's what he's telling us.
Yes.
My point is that if our own legal counsel is telling us we can't do anything about this issue, why don't we just cut this conversation off? Because I think the decision's already been made,
We
right?
need to change the statute or whatever it takes to get what was intended and has been acted upon since the board's been in existence.
But that's a legislative.
Well,
you know.
we're changing rules every day.
I do think
It's easier to change rules than legislation, don't you
I
think?
do think that, I mean, my opinion, lowly opinion as a non-committee member, is that if this is we do a disservice to the public to have this conversation every couple of years. So I think we need to try to get rid of any ambiguity whatsoever in the rules. And I think one way to do that is to insert the word firm after CPA before the and the or. So we're clear that we're talking about CPA firms and PA firms. I think that's at base, we have to do that if this is what the position is. We've got to get rid of the ambiguity because it doesn't do anyone a service for us to continue to deal with this every couple of years. That's my opinion. And we can change the rules, I mean, obviously.
I do have one question, and perhaps we need to carry the discussion just a little bit further, Trey, to
Okay.
answer this. We understand the issue with H&R Block. The next question in my mind is, if you are a CPA out there preparing tax returns, can we require you to register as a firm, which we have done in the past historically?
I think,
And if we cannot, then you all need to understand the magnitude of what's going to happen there.
yeah, explain the magnitude of that issue, because that's what I'm trying to get to is what does this mean for us?
Well, that means that with CPAs that are not registered as a CPA firm, we'll have no way of tracking where they're working or what they're doing as far as tax prep goes.
Right.
You're going to lose some revenue, an insignificant amount, but you need to be aware that you're going to lose some revenue from firms. But we
Elaborate on that. Who's going to lose revenue?
Well, we hadn't had them registering up to this point anyways, right?
Yes, we have. We have
H&R Block?
No, well, not H&R Block. We have individuals out there who are doing tax
if
prep.
all they're doing is tax practice work,
Yes,
then
and we have required them to register as a firm.
yeah.
And we have
In
those
addition to
registrations.
being registered as an individual.
Well, we have no choice. I mean, we can't require H&R Block to do it. I don't know why we would be. We have no choice. How could we require other like practices to follow that same logic? I mean,
And that's where I'm going. I mean, if that's the case, then
I mean, my point is our hands are tied, is the way I see it. And if that's the case, then all these firms that are already registered with us, I guess, will deregister or whatever it is, won't re-register, and we'll just have to live with that. I don't see any way around that. If the rule is, as we're talking about changing it, then we lose those firms.
But I think you're talking about a very narrow area of practice.
Well, if all
How
you
does
do
it-
is tax work.
But you're still, I mean, accountants do a lot of accounting in preparation to do tax returns. I mean, it takes sometimes in a lot of cases it takes a lot of accounting work to do a tax return.
Well, we're primarily, I guess, talking about 1040 prep, right? I mean,
But the accounting.
well, I guess
according
you
to
get into
this,
the
it's only a
companies and
test. And if you're just doing bookkeeping, which we call accounting, then that doesn't come under his definition. A test meaning you're, the letter. So, I'd
blown our rules up.
I think our legal interpretation here, the definition that we're receiving here today is, I'm not saying it's wrong. I'm just saying that we need to do something to try to deal with that issue.
Tony, do you have a recommendation in that regard?
If the board, I have to be careful the way I have to be careful the way I approach it. Because I work for the department, we're executive service, not of the legislature function, but I can tell you the process of procedures, which is, it doesn't appear to me that your statutes and rules would give you the authority to regulate that at this time, and if you wanted to change that authority, it would have to be done through the legislature, so you would likely need a statutory change in order to do that.
Meantime, basically, we should not pursue individuals that we've been pursuing.
Yes, that would be my recommendation. One, base, I don't think that the board has the authority to do it within the rules and the statutes. Number two is there was a recent United States Supreme Court case called North Carolina State Board of Dental Examiners versus the Federal Trade Commission, where the United States Supreme Court held that a board, the Dental Board of Examiners from the state of North Carolina, found that the board members individually and personally, without protection of the state, were held to have conducted anti-competition, were held in violation of antitrust provisions because they were attempting to regulate persons that were not under the purview of their board. The court went on and cited basically a test to look at those things, and this board matches some of those functions of that test of things to look at as to whether or not they would have protection. Some of the things that this, I don't necessarily want to go through all of those different things, but it looks like, and it's a non-negligible issue. It's a non-negligible concern that I would say that you all may have to have regarding this issue. After some individuals here, there were letters that were sent out by the board to individuals who were conducting these activities, and it basically set out you should be working for a registered firm, and some of these individuals actually did stop working for several months. After this came up, after legal was actually notified and understood this issue, we found out that what it was going. We basically sent out a letter. I did to 19 people that had received this letter, basically indicating that please don't change your current status of your employment or whatnot as of right now. We're going to bring this to the board in April, and that's what I'm doing now, so that I could at least give you a legal interpretation. So I just want to make you all aware that that's kind of the impact that it's had thus far.
So
you need to make a motion or something to fix.
I think we're going to have, it's pretty, I'm not going to say drag. There's some significant changes that need to be made to the rules. One of them is the definition of accounting service. The question I have on the case is whether or not, I don't know if there's a distinction here, but again, getting back to the nuance of what we were dealing with was not whether or not we had the authority to, as a board, to control tax preparation or non-attest services, but it's the behavior of licensees. So licensees to whom we conferred a license. So that, I don't know if that nuance is different than the dental board case where the dental board was found trying to control people they don't have governance over. I don't know. But in this instance, I would argue that we absolutely have control over folks who have a CPA license from the Tennessee State Board of Accountancy. That still may not get us where that may not change your opinion, and that's fine. But there's some significant changes that we need to make to our rules, and I don't know, does your office, will they help us go through that piece to conform it to the North Carolina case?
Yes, we can definitely go through and look at in a rules committee, usually. However, yes, we can look through what are your concerns, what is the attempted change, what do you guys want to do, and then we'll look at the current rule and see if we could amend that rule within the framework to see if it helps to meet what you all are attempting to do. The difficulty in some of that sometimes is if it appears that it's attempting to broaden the scope of what the statutory scheme allows you to do, that's kind of where the analysis needs to be. What could do. But
what
yes.
I'm saying, I think
We're
that's
willing
okay.
to help.
Well, I think it's okay for me to speak for the board when none of us want to be personally liable for trying to extend governed beyond the authority granted to us by the General Assembly. The point would be we need to narrow our rules, I think, because what I've heard is we've got to change the definition of accounting service, and we've got to do a lot of other things because we were operating under one interpretation, presumably an interpretation of the rules that now doesn't seem to have any support, which is fine, but I think we need to clarify ambiguity, and we need to make sure we narrow the scope of the rules so none of us are in the same situation as what it sounds like some dental board examiners are in North Carolina.
We could do that. Then we'd be glad to sit with you all at the next meeting and go through that.
Or can we suggest that our own staff attorney sit down with his department, since he knows this law so
Before the
well,
next meeting, right?
and then bring us proposed
Right.
changes to the regulations, right?
Yes.
It actually works for me.
I get that, but I'm saying she's
But-
familiar with all the activities of this board. It seems to
Yeah.
make sense that the two of y'all would sit down and draft this and then bring that to us, because none of us are qualified to do that.
Right, and I just need clarification on what your intention would be. Like, what do you all want us to draft rules to do?
I'm gonna defer to Gabe
Okay.
because
I
this is legalese.
My two
I'm not-
suggestions are to clarify any ambiguity so this issue doesn't have to be dealt with by either the board, the society, or any other licensees in the future. Make it clear. And I think the focus on that is the rule that Mr. Crocker discussed a while ago, and that I think was the basis of your opinion. And then I think we need to go back through our definition section at a minimum and make sure that our definition section read correctly and account correctly for those different changes in making the ambiguity go away. And then I think we need to do a dragnet of the entire rules to make sure they're consistent in the same vein as we're talking about now with the authority the General Assembly has granted to this board. Those are my three. I said two, but three suggestions. And I would prefer that be done sooner rather than later,
Yeah, I
because
would
don't want to
agree.
be sued.
Yeah.
Okay. I think are we in agreement with that?
Absolutely.
I guess an added observation. I'm not sure that I'm enthused or endorse the state of Tennessee and the State Board of Accountancy leading the charge for on this issue without. Where does NASBA stand on it?
Every state's different, Bill, so I don't think NASBA's taking a position on this.
But if I don't quite understand why. It sounds like we are the only state that has raised this issue and have a major problem with it.
Well, it may have been our own actions at the last meeting that prompted where we are today. That's what I'm hearing.
And most of that was stirred by the P10 that raised the questions and identified people that were not
Previously,
in compliance based on what our total interpretation has been, at least the time I've been on the board.
Can I make another observation? And I guess I'm a little bit disappointed, I think, in the fact that it sounds like from Mr. Glandorf, and I think I have a unique view of the position you're in as being a former attorney for the state. First of all, I apologize for putting you and the agency in a bad situation. I'm a little disappointed, I think, that there wasn't more communication from the staff to the C&I legal piece on taking this action. We were all, none of us, Jennifer and I are attorneys, but none of us have expertise in this area of the law. So when we make a recommendation, we all are doing it in good faith. But something like this that affects someone's livelihood, if there's a question about it, or if it's an action is going to be taken on the interpretation of a rule or a law, I think it needs to be vetted by the General Counsel's Office of Commerce and Insurance. We report to them. They're our agency. They're our legal counsel. And my opinion would have been that nothing would have gone out until they okayed it and approved it. And I guess I'm a little disappointed that what has happened potentially has dinged the credibility of the board, the staff, the agency, the administration. And I would hope that in the future that these types of actions get fully vetted by our legal experts and make sure that everyone's on the same page before we take action.
Very well said.
Very good. Thank you.
Appreciate your help. Look forward for your assistance.
Thank you, and I have written down what you charged us to do with in the interim, and we will do that.
We're just asking them to come back with some corrective language, which we're not approving today anyway, so.
A motion for that.
Thank you very much.
Thank you.
Well, another non-debatable or controversial issue is fictitious names. Mark?
You have the white paper there, and I think this is something that the board has discussed several times in the past. How do we want to handle this? What do you consider misleading? I mean, we're bringing you names of firms that are that Karen and I don't agree on, or perhaps that one of us thinks is misleading, and letting you decide. I believe that you're going to need to determine what is fictitious. If there's one word in there that's fictitious, is that acceptable? Must you have the name or initials of the CPA owner? That's the type of guidance we're looking for.
But what is your recommendation?
Our recommendation is that fictitious firm names be allowed as long as they're not misleading. Here again, that's one of those things where if it's one word and it is a word, then Karen and I would probably agree to approve that. But if there's any indication that the word doesn't make any sense, like intro account, then we're going to bring that to you and let you decide.
Why is intro account misleading?
I'm not saying that it is, Bill. I'm saying that's a board decision. That word doesn't mean anything to me.
So
You
for
had
years,
some comments or Tumblr and
for years we have not. This has not been a major issue, has it? Until
We've not had as many fictitious firm names come up as we have here lately, Bill.
maybe you were.
I mean, observation, especially in light of the conversation we just had, it seems to me like the issue that we're faced with now, and I don't have the experience that all of you do in this, either in the industry or past service on the board, is that it's less about a name being misleading and more about a name that doesn't appear to be on its face rationally related to the accounting or financial services. And as a result of that, it seems to me like there's potentially two issues. The white paper addresses one of those issues, and it's what is misleading. And it seems to me like that's an under-inclusive term for us in terms of guidance, because if I don't know, Skyline Drive Service LLC, well, that's not misleading if the place is located on Skyline Drive, but it also a layperson doesn't know that's an accounting service, or if it's just a non-attest tax service. And so it seems to me like there's an ambiguity by only relying upon the fictitious names that are, quote, misleading. And we need to do something different and get away from that phrase, because, as I said earlier, I don't think this white paper really was on point or that helpful, at least not to me. And maybe we're in the age of social media with Tumblr and such that it's cool to leave vowels out of names or whatever. But that issue is more of an ambiguity issue and not a misleading issue. And so my opinion is we need some guidance on, do we keep it ambiguous and make the public and the people that are practicing this profession continue to try to understand what we mean by misleading, or can we provide clarity by creating a new rule?
Kim, do you have any observations regarding the issue?
Fictitious part of it is less concerning to me than the misleading part of it. Your rules are very clear on what should be the standards that the potential names need to go by, and it is within the board's purview to interpret those rules. So I know that in the past, just by looking at a letter that one of the applicants supplied, he showed that there was, in the past, names like Appalachian CPA that had been approved by the board. As you were pointing out, that's not really misleading. That's not like a max tax refund CPA. And so I don't know that the board would be concerned about something like that. That's not really that's not misleading in any sense of the word. I think that, as the director pointed out a minute ago, the fictitious part of it is not so much of an issue as it is the misleading part. And so any time that the director is going to have a concern about whether or not it's misleading, he's going to automatically forward it to you all. And then it's up to the board within your purview to decide how far do you want to stretch that definition of misleading.
Questions? Are you asking?
Not today, Mr. Blofus.
Before we get totally off of it, can you go back through the legal that we went through and see if there's anything that we have approved for action tomorrow from our enforcement that we're approving contrary to the advice we've just been given?
I think that has already been taken care of, but I will double check that before it gets
Thank you.
submitted tomorrow. Yes, sir.
Very good. Firm mobility.
Boyd, you want to address that?
I'll be happy to. I know Tennessee should be very concerned about, we're one of 14 states that allow for firms to come into Tennessee as long as they're not domiciled here and not register. It's important, I think, for the Tennessee State Board of Accountancy to encourage other State Board of Accountancy to reciprocate on this issue. It's creating significant problems for good firms, not marginal firms, but good local firms, local and regional firms of small and large, who are inadvertently and unknowingly violating statutes in other states who don't provide for mobility. All states provide for individual mobility. We all allow for individual licensees to come in and practice without a license as long as they don't have a firm location or a residence here. And every state trusts the other Board of Accountancy to regulate the individual. Tennessee and 14 states trust each other to effectively regulate the firm. We provide firm mobility. There are firms in Tennessee, as a result of the Department of Labor's recent release of the employee benefit audit concerns to some state boards, that have been contacted, and I'm getting calls from around the state on this issue, and have been contacted by other State Board of Accountancies and levied significant fines for unknowingly practicing in their state, having never set foot in their state, having never done a test work directly in their state. But for instance, if a firm in Tennessee is doing an employee benefit audit in Kentucky, and unknowingly there's some subsidiary domiciled in Texas or New Mexico or Oklahoma or Kansas, they're very aggressive in attacking Tennessee firms.
This did happen to me, by the way.
Pardon?
It happened to me.
And it's so unfair.
Yeah.
It's frustrating to get these calls. We trust other states, and all 50 states trust each other to effectively regulate the individual, but only 14 of us trust enough to say that Kansas, we trust that you're going to effectively regulate those firms in Kansas who may never set foot in Tennessee but serve a client in Tennessee, so that that firm doesn't have to register in Tennessee. If that firm violates any portion of our statute, you're going to be responsible for assisting us in the penalty phase, and we do that with individual mobility. My point is, as a board, we need to go on record and let these other states, the 34 states or 36 states that don't provide that mobility, to encourage them to come along with that. I think the AICPA and NASBA is somewhat neutral. The Institute's pressing it pretty hard, but states are concerned about licensure fees. I think the attest issue is a concern to them, but at the end of the day, it creates significant problems with interstate mobility. And it's important for Tennessee State Board of Accountancy to go on record and encourage states in a very polite and diplomatic way. But at the end of the day, if those 36 states aren't going to reciprocate with us on this issue, we need to carefully consider changing our rules to make that a quid pro quo deal. If you're not going to allow our firms to come in, we're coming after your firms that come in and inadvertently practice in Tennessee, having never step foot in the state. But good firms, I'm not talking about the marginal firms that are doing a number of interstate attest services, are the ones that are usually caught up on like this. And some states are reasonable in their approach. I'll use Texas as an example. They typically say, we understand it was an inadvertent action, just register, pay the normal fee, and we won't pursue this action. But there are some states that are levying $10,000 fines on one incident and requiring firms to be on probation and creating legal liability that's unnecessary. It's unfortunate, and I hope that the board will help us encourage these states that aren't allowing for firm mobility to adopt it, because it's a reasonable approach in today's internet age, and electronic delivery of services is so prevalent, and we're trusting each other on the individual mobility, but we're not doing it for firms, and it just doesn't seem appropriate.
Brad, how do you want us, or what are you thinking in terms of how we could participate or help in this?
A letter to NASBA and the AICPA supporting their position, and NASBA encouraging them to adopt a position in favor of firm mobility, and copying all 50 state boards of accountancy on the issue. We need to establish a position that is creating significant problems for good Tennessee firms. That same problem does not exist for those states that are not allowing it. In other words, they don't allow firm mobility. They're creating. The firms in their state are not having the problems and moving into Tennessee in 14 states, but our firms are having significant problems doing that same thing in their state. So
we'd be able to bring this up tomorrow at the meeting.
Sure. But what I'd like to do is, if we could have a draft of what you would recommend us submitting, because it makes sense. You know, why should we put our professionals at risk when everybody else isn't playing by the same rules?
Exactly. I'm not suggesting that we want to use the threat of some quid pro quo on the deal, but at the end of the day, if some states refuse to offer the same reciprocity and courtesy to Tennessee firms, it should be considered. I think there are 2 states that have that system in place for individual mobility that's no longer needed, but Pennsylvania and Georgia, I believe, were 2 states that only reciprocated with states that intended to reciprocate with them. So it's not without precedent, but I think it's something that we might not want to suggest until we give them time to change. I understand some states are moving in that direction, but some states are just dug into the fact that we'll never let a firm come in here, perform a test work, even though they're legally licensed in another substantially equivalent state.
Help us pursue this issue and support.
I'm all in favor of that.
Very good. Thank you, Brad. Mark, did you want to bring up the mobile phone issue? Okay. Do you have any other matters to come before the executive committee? If not, we stand adjourned. See you in the morning.
We're a long time ago. The attorneys aren't ready.
One person's going to be the one sitting there dealing with you. I was like, I'm not.